Ready and start. Mr. Rai, learned senior counsel for the respondents, has submitted that the submission is simply prosperous as there is no statutory provision or precedent to sustain the view that preparation of final decree in a suit for petition during the pendency of the first appeal against a preliminary decree would extinguish the right of the aggrieved party to pursue the said appeal further. It has also been submitted that the review petitioners as well as the present respondents were fully heard in the first appeal and thereafter judgment under review has been passed on merits. After considering the submissions and the materials on record, it is evident that the judgment under review was passed after hearing the review petitioners as well as other parties in the first appeal. It is not the case of the review petitioner that any of the contention raised in the appeal has been overlooked and not considered by the court while passing the judgment under review. The submission that the proceeding of the first appeal against the preliminary decree would become infructuous or redundant after the preparation of the final decree is not supported either in principle or by any precedent. The further submission that the appellant in the first appeal would be barred by the principle of estoppel to pursue the appeal after the preparation of the final decree is clearly misconceived and is rejected as such. Moreover, all these submissions were admittedly not made on behalf of the review petitioners during the course of hearing of the first appeal. The principle is also well settled by the apex court in the case of Haridas Das versus Usha Rani Banik, AIR 2006 SC 1634 bracket 2006 bracket 2 PLJR SC 270 bracket close, as well as in the case of Kamalesh Verma versus Mayavati, AIR 2013 SC 3301, that the jurisdiction in review is not a jurisdiction in appeal and the scope and ambit of a review jurisdiction is circumscribed by the provision of Order 47, Rule 1, CPC. This court concludes that there is no error apparent on the face of the record or any sufficient reason warranting the prayer for review as made. As such, it is held that there is no merit in this review application and the same is accordingly dismissed.